Good afternoon, everyone, and welcome to the latest in our series of free webinars. Lockdown has made most of us think about our personal business lives, and for us at DG Legal, we decided to take a different direction by offering a series of free webinars. Back in March, we would never have imagined that the virus would still be around, dominating our lives now in October. This is the 14th webinar we've produced since March, and there are many more in the pipeline. Today's topic is the latest in a series of 6 peer review webinars. And today we're focusing on the housing category. We'll also be producing a peer review for the family category in a fortnight on the 27th of October. And we'll be offering training on other topics such as cybersecurity, confidentiality, conflicts of interest, etc. This Zoom event is in webinar rather than meetings mode. This means that we cannot see or hear you. There is a chat button and there is a Q&A button, and I'll come back to the Q&A in just a few moments' time. Going back to, I will mention Q&A now. It's better to use the Q&A facility to ask questions rather than the chat button, but we will see it if you do use the chat button. It's likely that we won't have time to answer all of your queries. We shall, however, answer all questions after the webinar and provide you with a link to the answers. The session is being recorded, and a link to the recording together with the slides will be sent to you. Now I introduce today's speakers. We have Professor Avram Sher, Melanie Gonga, and William Flack. Firstly, Professor Sher. He is the principal architect of a system of assessment of legal competence known as independent peer review. Since 2002, this has been used as the system for assessment of the quality of publicly funded work in England and Wales. What is truly remarkable is that he has also designed similar systems in Chile, China, Georgia, the Netherlands, parts of Russia, Israel, Scotland, and South Africa. Amongst many other things and many other achievements, he is currently chair of the Hamlin Trust and the Advice Quality Standards Project Committee. Melanie Gonga. Mel started her career in private practice and qualified to specialise in housing in 1997. After leaving private practice, Mel worked at a law centre where she spent 10 years as a supervising solicitor. Melanie has been a housing peer reviewer for almost 15 years, becoming a senior panel member in 2008, and has assisted in training subsequent peer reviewers and in writing the Housing Peer Review Guide to Best Practice. William Flack. William is a freelance solicitor and has specialised in housing law for the last 20 years. Before going freelance, Will worked as an in-house supervisor, then set up his own specialist firm. Will has been a member of the management committee of 2 law centres and has worked as a volunteer in the not-for-profit sector. He's also worked on the county court duty rotas and was a legal aid peer reviewer between 2009 and 2012. Will provides coaching and advisory services to organisations wishing to ensure that their caseworkers are providing excellent advice and are following best practice. Okay, thank you. I shall now hand over to Avram.
Hi, and thank you, David. What a build-up. Perhaps just a little bit too much, David. I'm going to be talking about peer review and quality. And first of all, I'm going to be trying to consider why it is that peer review has been chosen. Because at one stage, it might have been thought, as far as the Legal Aid Agency or Legal Aid Board as it was, and then the Legal Services Commission, that almost any approach to quality would be good.
Avram, sorry, Avram, may I interrupt you for a moment? You may wish to swap displays because we're seeing the full mode on the swap display. So that worked last time, I think. you know, the presenter mode.
Right. God. It is behaving badly.
So top middle, there should be something that says swap displays.
No.
Just to the left of it. And just, that's it, just there. Yeah, where your cursor was, it was just in the right place, just left click on swap displays.
Thank you. Is it here?
To the right a little bit. There, left click now.
That says Q&A.
Ah, okay. For us, it shows swap displays.
Shall we just continue with what we've got? Is that all right?
Yeah, of course it is. Absolutely fine.
Thank you. Okay, cheers. I'm going to close this. So, first of all, in 1992, we worked on franchising, and we looked at a number of different approaches, and we ended up with transaction criteria. And some of you may know or understand. Here we go, managed it now, David. Some of you may remember transaction criteria and what happened with that, but we did try peer review and we tried model clients as well. But we didn't actually get as far as peer review because we were told we couldn't use lawyers to look at any of these issues. Quality and cost was the research work that we were enabled to do by the Legal Services Commission, looking at over 143,000 cases, 83,000 completed, and what was in research terms the gold standard then, the randomized controlled trial. And we had different payment groups for the not-for-profit, we had different payment groups for lawyers, and we had a number of systems that we used in order to make the decision about what would be best to go forward. We used Briefcase as a means of looking at all the statistics. We used something which was new then called peer review. We actually had model clients going out and we had a client survey, and we learned from each of these. What were we looking at? Well, it was all of these inputs. First of all, we were looking at the sorts of things that all of you know that are inside your firm. These are the inputs: education, library training, knowledge, equipment, skill sets, etc. We looked at the inputs. We looked at the way in which the inputs were managed through structure. And of course, those were the things that can be looked at through other, quote, quality assurance systems and approaches. The next element, though, which is process, that's much more difficult to look at. Transaction criteria was aiming to do some of that, but we were only allowed to have people who were not lawyers making those decisions, and therefore we came up with long lists which they had to consider. Process needs other lawyers to look at it. And outputs is something that everyone wants, good outputs, either more money or stopping people doing things, or in other areas having short sentences or something like that. The trouble with outputs in law is that it's almost impossible to work out what a good output is for each individual case, because each case is so individual. And the result is that we needed something, once again, like a lawyer, to be able to look at each of the cases individually in order to know whether the output for any particular case was useful. So all of these together were something that peer review could actually handle. And my objective in talking about this is to explain and hopefully make it more understandable exactly why we approached peer review and what it attempts to do. Well, this is what we did in terms of peer review, and we found that there were a number of interesting areas of difficulty. That was selecting peer reviewers, training them, what criteria they were going to use in order to look at samples, and also finally monitoring all cases. We found that the reliability of the particular criteria we used could be problematic. choosing the right reviewers was difficult. Making sure that they actually all came out with the same results was problematic, unless we did a good deal of training. And in terms of what we should look at, we said we should double mark everything that we see, and we should only look at whole organizations and not just at single files, because what we were looking at was the management approach within an organization and how that worked out on process and on structure. And we realized that the result of this, looking at the files, meant that we were only getting an X-ray. It's not the same as surgery. We couldn't open up the body, but we could look at an X-ray, and that would be helpful in itself. So we got all sorts of results with our research. We saw some differences between the solicitors and the not-for-profit. There were 3 peer reviewers who were sort of awkward. One always gave everyone good results, one gave everyone bad results, and one never deviated from the middle. So we knew we had to do work on that. We found that it was different in different areas and also in different regions. But the large result of peer review was that it was difficult to hide what was going on inside cases. It was possible to see what was happening, and it was possible to make an assessment of them. We also sent out model clients in relation to peer review. We sent them out to 45 different places, and they were able to help us find out about access, quality of advice, and immediate follow-up. We only worked in a few areas, but they were enormously helpful. What did we find? Well, we found that there were, although the not-for-profit looked good in many ways, there were lots of access difficulties there. People had difficulty making initial contact and appointments and the actual advice system. And then when we got peer reviewers to look at the advice that was given to the model clients through the model clients' own understanding, and what was written to them afterwards, was that actually advice was really quite difficult. It was often inaccurate, impractical, woolly, and quite confusing to the model clients. And surely that would be even worse to ordinary clients. Here was what a model client felt about a particular advisor. Showed an impressive level of concern, made a point of telling me it can be quite common for part-time women workers to encounter unfair bosses. Overall, very helpful, reassuring, and personal. But when the peer reviewers looked at this, they said, well, this is a very clearly empathetic person, but doesn't really know enough about the law to be using legal aid money. So this was a good example of touchy-feely advice. We decided what was necessary was actually learning from all of that, seeing what clients actually got and what model clients received. And we could see much more from that, what they thought of what they'd received. And we could actually bring together all of these elements in the approach that we would use for peer review. And peer review was used on what we call a 2-track basis. It was random and targeted, and that still has continued. About half of peer reviews are totally random and half of them are targeted. Peer reviewers do not know whether they're going to see a targeted firm or whether they're going to see one that's totally been selected by random. We also asked for sensitive implementation, and it's true that no one was taken out of the system for peer review for about 15 years, but then well, the LAA started to make some changes. You must compare cost, old transaction criteria, and the compliance system with peer review. Peer review does not do the same things, but it does make you feel just a little bit like your belt has been pulled a bit tighter. So these were the problems that we saw in terms of peer review, and the result is that we worked on these issues: selection, training, the criteria, the sample, the monitoring of all reports that were going out, random and targeted. This is the whole world of peer review. It was used in all of these places. Peer reviewers themselves are reviewed every 2 years. They have to get at least a 2 in the system, and they need to be doing well. Here, for example, is the peer review criteria. You can see these on the website in relation to the process paper, and it looks in relation to civil cases, first of all, at communication with the client, next at the advice that's given, then the work and assistance which is carried out, and it asks the questions which you would think were appropriate. And then there is an overall mark for peer review, which is not the same as an addition of all the other marks averaged together, but looks at the overall quality of the work. So it's not possible to balance out bad work with good work in other areas, because every client should get a competent service. There's also specific guidance written for reviewers by reviewers, and that really takes me to the end of my talk, and over to Mel Gonga.
Hi there. I'm hoping you can all hear me, but David's told me he'll definitely shout if he can't. I'm just going to try and make sure I do now go into my slides, and hopefully you'll be able to see them. All right. Can you see my slides?
We can see it in preview mode, Mel, so just need to put it into presenter mode.
So remind me where I need to go for that.
So bottom right hand corner, there's a little icon that looks like a projector.
That's right. There we go. Okay, so I entitled my piece Housing Peer Review and What Does Quality Look Like? What do I look like? What do I look like? What do I look for, sorry, when I'm doing a peer review, when I'm looking at a firm. And I, as David said, have come at peer review from both a private practice background and from a not-for-profit sector background. So I'm hoping I've seen quite a lot of the variety that there is to work out there. And I think I also saw way back when there was a different standard applied to advice agencies that were not necessarily equipped to do court work, that were just there to do perhaps the preliminary advice and then the referral on. Well, things have moved on since then, and we now have a system that is intended to cover all types of provider, which means that across the board the standards we hope would be fairly consistent, or at least consistently applied in terms of what we think of as quality. I've themed my slides, so you'll see their rainbow colours. That's in part to reflect how we've all had to adapt the way we work in recent months, and I've tried to give a little bit of credit to both NHS and key workers and the Black Lives Matter movement, just because those have been things that I think during lockdown we've probably all seen and heard about and participated in, and as housing lawyers had a lot of empathy for. I think we'd probably look at ourselves as key workers. Okay, so I'm not going to read all of my slides, but I'll take you through hopefully the key points. Peer review is a process. There is an initial call for files that most of you may have come across. The call comes from the LAA. They ask for a list of files, usually closed files from within the last 12 months. They ideally want to have a sample of 5 files that are certificated matters and show that the provider has experiences dealing with litigation. And the remaining 7 are usually legal help matters. Now, it's true to say that not every provider will necessarily have that range of sample files, and I have seen providers who've had all legal help matters. That's not that unusual. The initial review is carried out by a single peer reviewer looking at 12 files. They, at the end of their deliberations, produce a report, which is just based on their sole review of the work and their opinions, applying the peer review standards. The process from there is that the provider will get a copy of the report, and if they score a 4 or a 5, will have an opportunity to make representations. Those representations will usually take the form of written reps, with an opportunity thereafter for the original peer reviewer plus a second panel member to have a look again at the files and see whether or not the concerns or criticisms hold up. There is an opportunity then to change the rating, as well as to amend the report and then send out the final report to the provider. For those of you that have had a peer review, you may be familiar with that process, but I thought it worthwhile perhaps outlining that. I've ordered my files in a sort of case progression order, the order that I would expect to see a file progress from start to finish. So no coincidences there if you notice that seems to be where we're heading. I start from taking instructions, and the things that I look for are generally whether or not there's thorough and complete instruction taking. Has the caseworker recorded personal data about the client, their family and financial circumstances, relevant health circumstances? In 25 years, I would say that I don't think there's a single housing case where health circumstances are completely irrelevant, whether it's a possession matter, whether it's a disrepair matter, an unlawful eviction case, it doesn't matter. I think you should ask about relevant health circumstances of each family member, because it may go to whether or not they ought to be evicted. It may go to whether or not the disrepair is particularly aggravating, or the effect that homelessness may have, and so on. It's surprising how many providers I see that maybe don't bother to ask that question, or perhaps don't record the answer. The housing circumstances and the presenting issues. I really want to see details of who the landlords are, when the tenancy started, in whose name the tenancy is in, what the rent is. Have there been previous proceedings? Alternatively, if it's a homelessness case, what was the last known address? In any possession matter, particularly those based on rent arrears, has the question whether or not there's been disrepair to the property been looked at and been asked and recorded? Are there any deadlines or urgency, and have those been recorded on the file? Are they then represented in a key dates sheet or some such on the file? There should be a preliminary note, at least in the initial instructions, of advice that has been given on the presenting issues. And again, it's quite common to see that where the question about disrepair has been asked on a rent arrears based possession claim, the question's been asked, the information's been given, but then the next step in terms of the initial advice on actually this disrepair is relevant to your case, that is sometimes missing. And then just brief advice on what the funding options are. Is it a legal help matter? Is it going to be funded by a certificate? The initial advice letter, in peer review terms, I don't think I can emphasize enough the importance that letter plays. It really does set up the file, and it is quite telling in terms of whether you're dealing with an experienced advisor as well, because it shouldn't just be a record of the client's instructions. Neither should it be a recounting of vast amounts of statute and quoting sections of law at clients. There's an argument about whether or not templates and precedent letters work, which I think to some extent it's very helpful to have a template, but to remember that it's a template only. It doesn't substitute putting in advice that is tailored and properly relevant to your client's individual circumstances. The advice letter should hopefully cover an introduction to the client, contain a summary of the instructions. It doesn't need to be chapter and verse. Set out what work it is that you're going to be dealing with for the client, and ideally that should mean that if you're dealing with a possession case in which there is a disrepair element, you reflect that. It should give advice on the law and procedure. It doesn't need to quote statute. It just needs to say what you're going to be doing for the client in the context of representation at court, and perhaps some of the factors, the arguments that might help, or alternatively that might hinder the case going forward. Should give an idea of timescales and give the client an idea of perhaps what they might next do to assist the provider in progressing the case, and similarly give the provider should set out what they intend to do to help the client and roughly when. Just a brief word on what the funding is would help. And I've seen standard client care information being given in a variety of ways. I've seen providers deal with standard client care information by leaflet, within the body of the advice letter, by sending out a secondary letter. I don't think there's any right or wrong in terms of how that information is given, and it's right that it must be given. But I think it's important to ensure that it isn't information that takes precedence over the individual advice that you're giving to the client, that is tailored to them, that they need. So if the client care information is a separate leaflet, or even an entirely separate letter, or is given at the tail end or somewhere in the advice letter, I'm probably more in favour of that than having it up front and central, and maybe the client not persevering to get to the very end of the letter where their tailored advice is located. So what are the next steps? I've seen a lot of files where providers have, they've taken instructions, they've recorded instructions and sent out an advice letter. And then things seem to come to a bit of a standstill after that. And that I don't think should happen. I think good quality housing law work means that you have to be proactive. It means that you have to follow up. It means that you acknowledge that our clients are not the model client. Our clients come to us with a variety of social needs and social problems. So it does mean that we find ourselves doing a little bit of social work in the mix, and it means that we need to be a bit more proactive in what we do to protect our clients. So as a basic requirement, I would expect there to be more or less immediate contact with the landlords or whoever the opponents were, the local authority or private landlord and so on. I would expect if there are court proceedings that there would be contact made with the courts to go on the court record if there's a certificate in place to ensure that the other side know that you're involved in the court action. I think there has been, particularly since 2013, 2014 onwards, a tendency for providers to shy away from using experts, from instructing experts and incurring the costs of experts. But I think that that isn't something that we should have moved away from, and I don't think that it's something that that today we should be shying away from. I think where the case calls for expert evidence, whether that's medical evidence, a surveyor as to the disrepair on a property, we should make sure that full and clear instructions are sent out to an appropriate expert, and that this gives them guidance on what it is that we're asking them to comment on, and that the disbursement is incurred where it's necessary. I know there were a lot of providers that worried that under legal help it wasn't possible to incur disbursements, and I think again that's sometimes a misunderstanding. Then aside from opponents and experts, have other third parties, relevant third parties, been contacted? I want to see that if it's necessary to contact the DWP about the client's universal credit claim, that effort is made, because sometimes, in fact quite a lot of times, if it's a rent arrears based claim, you've got to untangle those issues and know what is happening with the client's benefits in order to be able to explain to the court what's happening and give your client fair representation. It might also be that you can resolve the problem where a client has misunderstood what their entitlement is, or how and when their claim has started. Is there has contact been made with a social worker or a support worker? And might that person down the line be a helpful witness, or perhaps be able to give us information that sheds light on the client's background and how they've got to the situation they're in? And has appropriate funding been put in place? If it's a case that ought to progress onto a certificate, have steps been taken, and has the correct information been submitted to the LAA so that they do then grant funding? I know, and again, I've seen providers who are inclined to try and carry out all work under legal help. I would not encourage that, in part because, and not least of all, because your retainer with the client should cover you for court work if you're going to court for the client. You protect the client from costs to a large extent if you have a certificate in place, which isn't quite the same if you have if you deal with the case under legal help alone. Again, I've noticed that there are sometimes cases that tend to sort of peter out a little bit after the initial work is done. But where third-party inquiries have been made, have those been followed up? And has the evidence then been obtained, even if the initial request from the other party was not promptly responded to? Once you've chased up the evidence and you've got it, has that evidence then been weighed and considered? And in terms of how it affects the client's case, has the client been advised this is how this evidence affects your case? It's positive or it's negative, or do you think it covers all of the issues that we need to? Does the evidence suggest that further inquiries are needed? For example, you might have instructed a surveyor, and the surveyor may have reported on issues, and the client may say, but there was something else. Might it then be an appropriate time to go back to the surveyor and make further inquiries so that the report is as full and complete as possible prior to its service on the opponent or filing at court? And again, as I say, making sure that the client knows whether or not that evidence is harmful or of assistance to the case, and how that might then change your plan or change your approach. Okay, I've used the word representation here quite broadly to cover not only a representation in court proceedings, but representations that might be by written submissions, representations that might be by negotiations with the opponent, as well as the traditional way in which we as lawyers use it to cover drafting pleadings and attending court and undertaking advocacy. There is again a question about whether or not counsel should be used or advocacy should be done in-house. I don't think it is any criticism at all of a provider to decide to instruct experienced counsel to go along to court if they believe that that's going to create the, you know, cause the best result possible to be achieved for the client. I would just say have a list of specialist counsel and try to use experienced counsel that you've tried and tested, so you know what you're getting and you know that they know their stuff. I've next gone on to results and outcomes. I'm not suggesting that we are always going to be able to achieve the outcome that our clients want. Sometimes our clients' expectations are unrealistic. But whatever the outcome is, it's important that it fits, I guess. And on peer review, we'd be looking at, you know, based on this evidence, would this outcome be a reasonable outcome? If, for example, you have a client who has come in to see you and you've assisted them in resolving a large portion of the arrears have been reduced down to a relatively nominal level, was it then appropriate to agree a suspended possession order with your opponent? Might it then be argued that perhaps you might have fought for an adjournment on terms, or you know, or even suggested that the other side might withdraw the claim altogether? It's really about whether or not the outcome appears to fit the evidence and the circumstances, and whether or not in the journey en route to that outcome you've taken proactive steps towards achieving what would be an appropriate and reasonable outcome. If you've protected the client's interests adequately along the way, you've advised the client along the way how the evidence may impact on their case, it shouldn't come as a complete shock. I mean, I'm not saying that there aren't cases where you get you go along to court and you perhaps have a district judge who's hits you slightly left of centre and you know, comes out with an outcome or an order that perhaps you wouldn't have expected. But if that is the case, have you advised the client of that outcome, and whether or not that is something that might be challengeable? Have you advised the client in a timely manner about what's expected of them once an outcome has been obtained, once an order has been made against them? If there are terms of payment, if there are you know, terms of behaviour that they need to comply with going forward. If a client has been refused accommodation in a homelessness matter, have you advised them of their right to appeal to the county court and of the time limits that apply to that? If there is a need to appeal, whether or not that is something that has merit, have you advised the client that they may wish to proceed with that in person, even if you can't take it further forward because you've decided that there's lack of merit, or because the matter becomes out of scope? For example, on a disrepair claim where the client, the opponent decides to withdraw the possession claim and you're no longer funded to take the damages claim forward, have you advised that there are alternative ways in which the client can pursue the matter, even if you can't, and even if you choose that you're not going to go ahead? Some do's and don'ts. I don't think it's necessary to have typed attendance notes. I think there may be other peer reviewers who prefer typed attendance notes. I think provided they're legible and sufficiently detailed, I'm quite happy to read handwritten notes. But if you know you've got really atrocious handwriting and only you know, only you and possibly your very, very closest colleagues can read your handwriting, perhaps it would be best to have typed notes. I don't think a lengthy initial letter of advice to the client automatically equates to good quality. I think the letter might be long because it has to cover quite a lot of information, but length in itself does not automatically mean that you've covered the issues and that you've covered them appropriately to tailor them to the client's circumstances. please spell check your letters, because I've seen a lot of providers, perhaps maybe where they're using digital voice recognition technology, and it mishears, send out some very, very dodgy letters with very odd spelling mistakes, or at least I hope they were spelling mistakes and typos. I don't think you can assume that standard letters are best. I think probably the letters that work best are templates that perhaps use standard headings, but then are tailored specific to the client's individual circumstances. And maybe even if you have standard letters, you have either or paragraphs that that can be deleted where they don't apply to a client's circumstances. I do think that once providers often have a standard letter or leaflet in place, there is a tendency to then use that forevermore. I remind providers every now and again, at the very least annually, to review those letters and update them. Sometimes the terminology changes. Sometimes, for example, in the last couple of years, we've had the Homelessness Reduction Act. You need to update those letters so that they properly reflect what the current circumstances are of, whether it's the funding climate or the law and so on. I don't think it's necessary to quote specific legislation to clients, although you might wish to do that in letters to opponents and others. I've given a couple of do's and don'ts on the types of cases that we are currently funded to do. On possession matters, I'd pretty much always say, please don't start with an offer of a suspended possession order to the opponent, unless it's absolutely certain that your client's going to get an outright order, or where a suspended might be an alternative to an outright order on a mandatory case. I don't think that would automatically, an SPO automatically represents a good outcome. Yes, the client keeps their home, but have you put in place terms that are going to be, that the client's going to be able to comply with, and over a sustainable period? I think in warrant cases, you need to start by following or considering a full range of outcomes. In other words, should you perhaps be unpicking what's happened before, you ought to at least get hold of the earlier court papers, rather than assuming that everything that ought to have been done from a technical standpoint was done at the time the initial order was made, because it could be that that order was made in the client's absence. On homelessness matters, I think particularly reviews, please do get hold of the homelessness file, because the case isn't just about a factual dispute. It's also about procedural matters that the local authority may have missed, and that may well give you grounds to then appeal to the county court at a later stage. On disrepair cases, please do obtain expert evidence and do consider that and advise the client accordingly. And on lawful eviction matters, please remember to advise on the full range of remedies that the client might seek, including reinstatement if that's still an option, and if not, make sure that you advise on the full range that of damages that the client might be entitled to. Diarise dates. Diarise key dates, comply with them. Please don't let them go by without any word being said, or because the case has gone to sleep in the bottom of your filing cabinet, you haven't maybe you haven't realised that the date has passed. Make third party and opponent inquiries. Be proactive and don't be fobbed off, even if you've had to write 4 times to housing benefit before you get a response, or threaten them with witness summonsing them in order to produce the required result from them. Make inquiries in general of third parties, request housing files, medical notes, expert reports. I don't think it's necessary to get these just simply to bulk out the file, but I think you do need to actively consider relevant evidence and how it impacts your client's case. Update the client then on whenever there's a material development in the case. It's not your case, it's their case. It's important that they're brought along with the whole process. I'm not suggesting that you should bombard the client with so much information they can't choose. I think you need to break it down in terms they understand and allow them to make an informed decision that you can then take forward for them. I like providers that draft their own pleadings. I don't think that the standard defence form, for example, in possession matters always fits. Quite often it doesn't. It doesn't allow space for you to set out, to provide a detailed submission about your client's circumstances. It's great if you just want to give the court an outline of your client's income and outgoings, but it's not so good if you want to put a case on grounds of reasonableness. Please don't keep copies and multiple copies and then more copies of the same document on file. It may be right that you'll have 2 copies on file, but I don't think it's helpful to have 3 or 4 copies of identical documents on the file. And I do like files that are quite organized, so that there is a separate place for documents as opposed to your correspondence pin, which should comprise your work, the work that you've done, your attendance notes, and the documents that you produced or received from the opponent, such as letters, that sort of thing, as opposed to bulky pleadings. Pull your files out, I think, every month or so. If you haven't had an opportunity to work on a file during the course of a month, pull it out of the bottom of the drawer and have a look at what's happening on it, or what last happened on it, and what you ought to maybe be doing next. That might also help in terms of supervising more junior staff members and getting them to cycle their cases and work on them when or chase things up when they need to be chased. I think it's really good to undertake your own advocacy where you can. Attend certain panel meetings where you can. For example, we've had some cases recently, or slightly before the pandemic, where we attended review meetings with the landlords on whether or not a notice are served on Section 21 grounds, but on the basis of antisocial behaviour, whether or not that they should proceed to issue court proceedings. Sometimes it's material to the case and its outcome that you put in that little bit of extra work, and we've been paid for that, and I think it adds value to the case, and helps the client to feel that you're willing to go that extra mile for them, and that they attend the meeting and their views are heard. Know your funding. Know what point up to which you ought to perhaps use legal help, and when you ought to switch on to certificated work, or whether a case ought to simply start from a certificate from the outset. Make sure that you give sufficiently detailed notes to show what work you've done, and that you'll then get properly remunerated for it. Notify clients of the outcomes and what's expected of them promptly. Please don't wait until a month has passed and they've already missed 4 payments that were required of them under the terms of a suspended warrant to send them out a letter. And don't assume that simply sending a copy of the court order is self-explanatory, because it won't necessarily be for a lot of our clients. And finally, common misconceptions. Peer review isn't about auditing your costs and what you've claimed and the quality of your form filling. I'm not particularly interested in how well you've completed the form, but the LAA might well be. So it is a good idea to complete it properly. I'd also say I'm not particularly interested in the time you've claimed, provided you've given sufficient detail. You claim what time it takes you to do the work. It's not necessarily the case that if you use a typed attendance, typed attendant notes, you're going to score best. If you have legible notes and they're thorough, I think that will be fine. You don't need to use standard template letters. You don't necessarily have to have tidy files, but I think because you're expecting that somebody else who doesn't work in your firm is going to be looking at the case, they ought to be orderly, or there ought to be a discernible system. Big files don't necessarily score best, and that's one of the reasons why I'm saying don't keep multiple documents or copies of the same document in the file, because bulking out the file doesn't automatically mean you've done a lot of work. I don't think using legalistic language shows that you know what you're talking about, or demonstrates to your client that you know what you're talking about. I think breaking it down in terms they understand for the particular the client and the level of understanding that they have is really important, and it's important as part of the process that we bring our clients along with us, and that they have a better understanding of what they might do in future to avoid the same problems occurring. Once you've advised the client, it's up to them to follow up and progress their matter. Really, it isn't. It's up to you as the legal advisor to progress the matter and to prompt. I don't really like providers that send clients off to gather their own evidence, to interview their own witnesses and produce their own witness letters. I really do think it's helpful to say to a client, think about who you'd like and maybe have a word with that person. Would they be willing to be a witness? But then it is up to us as the representatives to follow that up, to send out letters, to make phone calls, and to interview the witnesses or third parties. Again, I think after the 2013 contract, there was a tendency to assume that you couldn't do any housing benefit work, or you couldn't do any benefit work at all. I don't think that's the case, and I don't think I'm going to shy away from saying I would mark down a provider that doesn't carry out any relevant benefit work where it's necessary to understand what's happening on the client's benefit in order to be able to understand how they've gotten to the position they're in. Making inquiries of housing benefit does not make the case a housing benefit case. It makes the case for having all of the information before you when you appear in court. Sending the client off to do the housing benefit work themselves often does not work, and you'll get adjournment upon adjournment, if you're lucky, where the judge is perhaps getting less and less content to give adjournments because they can't see that progress is being made. Another common misconception is that disrepair work is no longer covered by legal help. It is. You do have to show that it is serious, and that there's an impact on health. I don't think that has to be the evidence at the start of the case has to be overwhelming, but you do have to make a note of why you've considered that to be the case, and then to maybe make inquiries down those lines in terms of expert evidence and medical evidence. Unlawful eviction damages cases are not covered by legal aid. Again, that's a common misconception. Damages only claims for disrepair are not covered by legal aid, but damages only claims for unlawful eviction are. I'm not allowed to incur disbursements under legal help. Yes, you are, and legal help does not impose a fixed limit on how much you can spend, provided those costs are reasonable and provided you've had reference to what the relevant hourly rates are that are permissible. You'll be judged more harshly on peer review if you don't get the outcome your client wants. No, you won't, but you might be judged more harshly if the outcome seems to be way off what the evidence would have suggested, or what you might have achieved if you'd maybe followed up or made relevant third-party inquiries. Again, and finally, doing all the work under legal help is not necessarily helpful for your client, particularly in terms of cost protection for them. I think that's me done. And if you noted that there was any similarity between what has been said here and in the housing guide on peer review, I make no apologies. That's deliberate. I would point you to that. It is useful and it is quite helpful as a guide to what you perhaps ought, to the work perhaps you might you maybe ought to be doing. Thanks. I'm going to pass back now to David, or should it be now?
Yeah, no, I'd just like to say a couple of words before we hand over to Will. We're coming up to 2 o'clock, so we are going to overrun a little bit, and I think the rules of the game are a little bit different with webinars compared to face-to-face training events where people have got trains to catch, etc. So I'm quite happy for it to overrun. So we're gonna go to probably around about 10 past, quarter past, I would imagine at least. So apologies that we are a little longer than we expected, but for those that do need to leave, there will, as I promised earlier, be a recording and a copy of the slides available. So without further ado, Will, over to you.
Hi, hello. I'm just going to share the screen with you and get my slide going, which should be there. Right, hopefully you can see that. And I'll try and follow up. I think Mel's covered an awful lot of the most important stuff. What I will do is try and give you some idea of where people go wrong and tips for how to avoid that. I should say to begin with that I certainly haven't learned the secret of how to avoid going wrong. I'm still learning all the time myself. And so with that in mind, the most common problems I find in people getting bad marks on peer reviews, the first one is untrained and unsupervised staff running cases. It's very, very tempting, and it's not necessarily a bad idea to involve untrained, unsupervised staff in certain roles, such as data gathering. You might get that in a sort of NHS triage, that you speak to somebody very junior when you first go to A&E, but you see a consultant at the end of it. But the tendency is to leave those people running the case all the way through. And although there may be good intentions to supervise them, the supervisors are often too busy to do that. And so you then get a situation where somebody never really understands the case or what needs to be done with it. A second problem I find is very long handwritten attendance notes, particularly at first meetings, which are difficult for anybody else to read. And that does come down to not just bad handwriting, but also badly structured, because the note can be written in a sort of, well, a note form where it's not a verbatim record. And it's not just difficult for the person who didn't write it, but it's often difficult for the person who did write it if they come back to it after anything other than a very short time. And then the other question, which is sort of the other side of the coin of that one, is the problem of important questions not being asked. And again, if you're not familiar with the area of law, you may miss them, but the most obvious ones would be possession cases where there's a disrepair counterclaim, or there's a medical condition which may contribute to the problems, or say an intentional homelessness case where there's an argument about rent arrears, but it turns out the landlord was selling the property anyway and nobody asked that question. So important questions are missed and make problems for the whole of the case afterwards. Again, this one's obvious, is deadlines being missed and files becoming inactive. I mean, I'm not saying these are obvious things you should avoid. They're just things that people tend to get wrong, and you see files which have obviously not had activity on them for a long time. And that can be compounded by people then sort of becoming scared of the file and the client and avoiding the calls from the client, and things spiral into complaints and things going wrong. So those are some of the worst types of things, or the most common major underlying problems that give rise to bad peer reviews. And here's some tips or ideas for avoiding those. I mean, using a checklist for obtaining instructions, or checklists, I should say, that will help people who are not necessarily very experienced, because they can just go through the list of questions. They can make sure they get the names and dates of birth of all of the children, the medical conditions of the family, and you've then got a proper record that you've asked all the questions. Now, the next thing I'd say is, it's not necessarily enough just to fill in a checklist so that you've got a load of answers on the file. I think a very good practice is to turn the answers that you get and the information you get at the first meeting into a statement of case. And that should be written in the first person for the client. I'm not saying it's a witness statement, and a lot of barristers panic and they say they think I've sent them a copy of something that's gone to the other side, but it should be a record of what the client's problem is and what their circumstances are. And the advantage of that over an attendance note is obviously you can send that to the client and ask them to approve it. You can then edit it if it's on computer form. You can use it as the basis of your of a witness statement later on, of a statement in support of an application for a legal aid certificate, various things like that. And it avoids a very long advice letter, which often you get people just reciting what's in their attendance note. It's sort of copied and pasted rather clumsily into the advice letter. Whereas if you say the details of your case are set out in the statement of case, your advice letter can then go on to summarize the problem, and also, and this is very important, the solution to the problem, because a lot of people forget to ask the key question at the beginning of a case because they're sort of preoccupied with often the sort of car crash that they're presented with, to say, well, what is a favourable outcome to this? What are you actually looking to achieve? And it may be that they don't want to get evicted, but they may tell you, well, actually, I don't want to live here anyway because there's I'm a risk of domestic violence or something here, which meant that you've missed the whole point. And so asking that question is important. So moving on, the advice letter enables you to combine. If you send the statement with the advice letter, you've got a good record of the presenting problem and hopefully a summary of the presenting problem and the outcome. And then I would suggest having a second section which sets out advice. Now this brings us back to that perennial problem for lawyers as to how much advice you give. And I agree with Melanie that the less, you don't really want to be quoting statutes, but sometimes it's impossible because the case, say in a homelessness case, you probably have to give an explanation of what a Section 202 review is and what different things are. But I would suggest that concise chunks of text are used rather than long copy and paste extracts from textbooks, which I have seen in some cases where advice letters can go on for 20 pages, most of which is irrelevant. So after setting out the sort of objective law, then there should be a second section in the advice which sets out the subjective part of how that law applies to the client's case and what the prospects of achieving the desired outcome are based on that. And then I suggest that the advice letter has further sections. One is stating precisely what the solicitor's doing at the moment or has done already following the first meeting, and that could include enclosing copies of letters which have been sent. A second section of what the solicitor intends to do or proposes to do, and then hang on a sec, sorry, I think I've missed, I should be on the next slide here, sorry. Yes. And also what the client's expected to do. And once you've done that, the advice letter serves a really important function, or a number of important functions, perhaps the least of which, and I may be committing heresy here, but the least important of the functions in many ways is advising the client, because many clients don't read these letters. If you say to them, oh, did you read what I said? Oh, no, I got as far as the first page, but then I missed it. But it's so important for getting a sense of being in control of the case, because once you've set it all out, you know yourself where you're going with it, and you can come back to it a week later and think, what was that case about? And then it's there. And anyone else taking over the case automatically has that. And then one thing I'd say is follow up on, I think that might be one more. Follow up on the review dates. Where I've said that you should say what you're doing and what the client should be doing, make a note to review that and if it's happened or not, and then come back and be tough about those things. If the council don't respond to you in 14 days and you don't get the file in 28 within a month now under the Data Protection Act, make a note to send a chaser letter and then a follow-up letter and a formal complaint if necessary. And the same thing for clients, because one of the problems is, a common problem is that if clients don't provide instructions, some solicitors will just say, well, I'll just put the file in the cabinet, and if they get in touch, I'll deal with it. But that way leads to disasters where the client thinks you were doing something. So you really have to follow up on the review dates for them to do things. And if they don't get in touch or do the things or give you an explanation, you have to suggest you're going to close the file. And then there's no suggestion that you didn't do what you were supposed to do. And that brings me on to the last of my points, is to confirm telephone conversations in writing. When I was preparing for this, I watched some of the other courses, the immigration one and the mental health, and there was a sort of mantra that I agree with, that the peer reviewers from there said that if something isn't written down on the file, it didn't happen. I would add to that to say that if something is written down on the file but didn't go out to the client, it's arguable that somebody else will say it didn't happen and that you wrote that later. If somebody makes a complaint, a common response is, did you tell them that? You say, yes, here's my attendance note. And the client will then dispute that, and somebody will say, well, you did send them confirmation of that, didn't you? And you go, well, I didn't. No, I just put it on the file. So it's best to send those things out. And it does make a difference for clients. If they have a conversation with you, it may go in one ear and out the other, and they may forget what you said. And just to say, I'm just writing to confirm that we talked about this and I'm going to do that, it can make them feel that they are getting a good service. And it can also help you to remember what you're supposed to be doing. So I think that's everything I've covered, I wanted to cover. I'm sorry if it was a bit rambling and my slides were very boring compared to everyone else's, but that's all I've got to say for now.
That's great, Will. Thank you so much for that. And yeah, time prediction absolutely spot on. It's 10 past. So with questions, I think we can fit in a couple of questions because we've only got 2 questions. Now, the first one, which has been answered by Avron, but I'm going to invite comments from Melanie as well, is as we move more towards a paperless world, are you content to review cases on a case management system rather than a paper file? And Avron has said it is possible to send digital files, but it's a good idea to check that they are understandable to a lawyer not from your firm. So Melanie, what's your experience of that?
Can you hear me?
Yeah.
Okay, great. My experience has been quite varied, actually, because it really does depend on how organized the electronic file is. And it doesn't look like a file. So for us as lawyers, we have to, particularly if you're dealing with lots of different providers, you have to retrain your mind to know what to look for. So I think the file that's coming to you electronically has to almost mirror what you would expect a paper file to look like, so that you have the structure and the organization of what you're looking for. So for example, if you just get an electronic file that's got lots of data in lots of different places or lots of different files within the file, how do you work out where the file begins? So I think it does come down to having a very good sort of case management system, or a very, very good digital system that means you get a sense of a start, a middle, and an end to a case, and the events that happen as you go.
Okay, Mel, thanks for that. Now, the second question here, which I think is not really a peer review question, I'm going to ask Will to comment on that, and I may add some comments. The question is, I note that inquiries with housing benefit, universal credit in possession matters are covered under legal help and certificated matters. However, what is the extent of work that you can carry out with the DWP, i.e. when will fees be cut by the legal aid agency? Do you have any experience of that, Will?
yes and no. I mean, I haven't had that much experience of them cutting fees. That doesn't mean that I get a green light for them to merrily sort of enter into long correspondence with DWP. But I think the bottom line here, and Melanie may correct me if I'm wrong, is that if it's necessary to resolve the actual possession problem, so that if somebody's housing costs are not being paid in full, and that's something that is being talked about at the court hearings, then it's justifiable to carry out the work, if only to obtain evidence for the possession proceedings. Resolving a benefits claim as a sort of self-contained issue wouldn't be covered, but where it's central to the housing problem, I think you will be paid. I mean, there's always going to be a danger that somebody at the legal aid agency may think this is an opportunity to make a cut which they should be seen to be making once in a while, and that will be one of the areas. So I think that the key thing to do is to make sure that you phrase it in terms that it's central to the housing case. So when writing to the DWP, you make the point that this person's facing the loss of their home and I'm writing to you because of that, rather than just they're not getting all the benefits they should. That's my answer to that.
No, I think that's a perfect answer. I don't, unless Mel, there's anything else to add? I don't think there is, though, is there?
No, I would agree with Will. The other thing I was just going to say is that I've done a mixture of adding entries into clients' universal credit journals with them to resolve a lack of housing costs or lack of the DWP processing and paying the claim, which is causing the client financial difficulty and rent arrears. I've done everything up to but excluding the actual tribunal on a housing benefit matter, and I've done I've done everything up to again, but excluding representation on other benefits where I write to the DWP and make a submission, because let's face it, if it is as Will says, central to the client's housing case, for example, their ability to pay rent, their ability to keep up with any arrears payment that's due or that the court may order, you can't very well go ahead to court and have that order be made, which then is going to put the client in a position where they'll immediately breach. So you have to make those inquiries, and I think you make a decent attendance note of it, and the LAA will accept that.
Okay, Mel, thank you very much. I'm just going to finish off now by just confirming that, yes, the slides will be available afterwards. I can see we've been asked that question. And the slides will be available, as will the recording. And also the Q&A, although the Q&A is actually quite short this time round. I'd just like to finish by saying, if you appreciated today's free webinar, I'd be very pleased if you could make some comments. When you close the screen, you'll be invited, if the IT works properly, to leave your comments. If you could go even further and leave a Google review, we would be enormously grateful. You can do that by Googling DG Legal and selecting the leave a review button. To reciprocate, we'll send you a detailed housing file review form, which addresses the common issues that housing peer reviewers find, which we think will help you to pass the peer review. So it just remains for me to say thank you very, very much for taking the time to attend this webinar, and I hope you have a good afternoon and evening. Okay, and thanks to all the panel members. You've been brilliant. Thank you all.
Thanks.
All right, bye everybody.
Bye.